In the previous video, we began our discussion about the various duties of trustees, and these duties are a lot more wide-reaching and onerous than the fiduciary duties. And we've already looked at, for instance, the duties to familiarise themselves with and observe the trust instrument, and to exercise their discretion and consider their powers, etc. And this just leads on from that previous video. So if you haven't seen that video already, I would recommend you check that out first, because this is just a continuation of more duties that trustees will owe. So the next duty is the duty to take care when dealing with the trust property. So there is a general duty to preserve the trust property, and this includes the duty to ensure that money is invested suitably and that any chattels and real property are looked after. However, the trustees are liable if trust property is lost or destroyed by their failure to take custody of it. But if they act with reasonable care, they are not accountable for losses caused by their agents or servants. So, the duty of safeguarding the trust property is fundamental to the notion of trusteeship and to the operation of trusts. Consequently, it can easily be understood that the trustees are responsible for ensuring that no harm comes to any property which they hold on trust. Thus, a trustee holding a house on trust would be required to ensure that the house was kept in proper repair. A trustee holding a horse on trust would be required to ensure that the horse was properly stabled and so forth. Okay, and at this introductory level, we can understand the trustee's obligations as being obligations to prevent the property from being broken, run down, or worthless. However, there is a further dimension to this duty, which imposes active obligation on the trustees to consider the best interests of the beneficiaries, and so to consider the most appropriate way of maximising the utility or the value of the property as applicable. Therefore, if the property is investment capital, then the obligation of the trustees are to obtain the most profitable investments. We can see that from the case of Scargill in 1985, commensurate with the type of trust in question, and that's from Nestle and National Westminster Bank from 1993. Whereas if the trustee's underlying objective is to provide accommodation for the beneficiaries, then the trustee's principal obligation will be to secure the maintenance and utility of the property so that it is fit for purpose. In either case, the trustees have active duties to safeguard the trust property so that it remains suitable for the trust objectives and may not simply just watch over the property and preserve it from decay. Okay, so let's look at a case. Actually, before we look at one particular case, I'm just going to make a note about the agents or servants. So a trustee can authorise an agent or servant to exercise any or all of his functions. Now, if he does this and the property is lost or destroyed whilst in the hands of the agent or servant, then the trustee will not be liable so long as he has complied with the statutory duty of care applicable to him when entering onto the arrangement. In other words, so long as he has exercised reasonable care and skill in selecting the servant or agent. So let's look at a case. We've got a couple of cases here. We've got Lewis and Nobbs from 1878, and in this case, trust property was invested in bearer bonds which were divided between the two trustees. One trustee absconded with his half of the bonds. So a bearer bond is a type of financial instrument which pays a fixed fixed amount to whoever happens to be in possession of them at the time. So if you are in possession of the bearer bonds at the time and a dividend is due, you get the interest paid to you on the bond. Okay, so bearer bonds are bonds that are not registered in anyone's name and payable to whoever possesses it. And so here the bearer bonds were divided between the two trustees. One trustee disappeared with his half of the bonds. And because they are so valuable, because bearer bonds are so valuable, they're very easy to sell. So the trustees clearly sold them for a lot of money. And we have a quote from Hall here from the case, who said that the duty of the trustees was to make an investment in the names of both so that the bonds should be transferable without the action of both. Or, as the bonds were transferable by delivery, care should have been taken that there could not be any improper disposition of them. The arrangement made by the defendant Nobbs being improper, he is liable for the illegal dealing with the moiety of the bonds of his co-trustee. So Hall said that this was a breach of the duty to take care of the trust assets. The trustee that did not run off by failing to take sufficient care was in breach of duty, so was liable for the loss himself. So this was so even though he hadn't actually caused it. So obviously the one that ran off was in breach of duty, but the other one, by not taking reasonable care of the trust property, was also in breach and was therefore liable for the loss. And very quickly, we've also got this case of Ogle, Smith and Pilling from 1873. So in this case, wine was held in trust. A trustee failed to take steps to collect wine from a debtor. The debtor drank the wine. The trustee was held liable for the loss. So he should have taken possession of the trust property. And then we've also got this case of Jobson and Palmer from 1893. In this case, the trustee was not liable for the theft of a watch by one of his servants, since he had exercised reasonable care and skill in selecting the servant. So there's the duty of reasonable care of looking after the trust property, and we talked about how a trustee can authorise an agent or servant to exercise any or all of his functions, and so long as he's exercised reasonable care and skill in selecting that servant or agent, then that is okay. Okay, so the next duty we're going to look at is the duty of care in investing the trust property. Okay, so most trust property will either be held in land or in some form of financial instrument. For example, fixed interest bonds, shares in listed companies, government bonds, etc. And the trustee's obligation in 19th century case law was to act as a prudent person of business would have acted if acting on behalf of someone for whom she felt morally bound to provide. And so the classic case or the classic statement of the duty of care is set out in Gaunt in 1882 as the standard when dealing with the trust property of an ordinary man of business. So the duty of care required of the trustee when dealing with the trust property used to be that of an ordinary man of business. And the quote from this case was, "It seems to me that on general trust principles, a trustee ought to conduct the business of the trust in the same manner that an ordinary man of business would conduct his own, and that beyond that there is no liability or obligation on the trustee." So clearly this may be a difficult test for a trustee to observe, particularly if the trustee is not acting in a professional capacity. So this was slightly amended in Whiteley in 1886, which sets out the current standard of care. And that is to take such care as an ordinary prudent man would take if he were minded to make an investment for the benefit of other people for whom he felt morally bound to provide. So because an ordinary man of business may have had some rather speculative investments and take the risk, the updated standard is more prudent. So historically, trusts have been invested conservatively, where the prime aim was to maintain the value of the trust fund, and generating capital was seen as a secondary to the importance of maintaining the value itself. Now things are slightly different, so the duty of care standard has actually changed. So this sets out the current standard of care when it comes to running the trust. So the duty of care now required of the trustees when dealing with the trust property is the care that an ordinary prudent man would take if he were indeed to make an investment for the benefit of other people for whom he felt morally bound to provide. And the case law principles have been displaced in part by Section 1 of the Trustees Act 2000, which provides a statutory level of care. And Section 1 of the Trustees Act 2000 provides the following. provides a statutory level of care, such skill and care as is reasonable in the circumstances, having regard in particular to any special knowledge or experience that he has or holds himself out as having. So, for example, if he is a skilled investment advisor or claims to be a skilled investment advisor, he'll be held to that standard. Okay? And secondly, if he acts as a trustee in the course of a business or profession to any special knowledge or experience that it is reasonable to expect of a person acting in the course of that kind of business or profession. So what Part B tells us is that if you're operating as a business, then your standard is even higher. Okay. So the focus of Section 1 of the 2000 Act is that the trustees must be held to a subjective standard of care commensurate with any knowledge or experience which he already has. The test is subjective in the sense that it is reactive to the trustee's own knowledge and experience, and the standard of care that is required will be a standard of care which is reasonable for someone with that knowledge or experience. If a trustee is foolish enough to represent herself as having knowledge or experience when she does not, then the trustee is held to the standard of care appropriate to the knowledge and experience which she claims to have. That's Section 1A. Similarly, if the trustee is an incompetent professional, then she will not be held to her low level of competence, but rather to the level of competence which one ought to have been able to expect of such a professional. And it's also interesting to note that this statutory duty of care may be excluded by the trust instrument, and that can be seen in the Trustees Act 2000, Schedule 1, Paragraph 7. And this duty of care is primarily concerned with powers, for example, of investment, and applies to the manner of their exercise and not to the trustee's decision whether to exercise them or not. And just to wrap up this video, I want to quickly talk about 3 cases regarding the duty of care in investing the trust property. So in Bartlett and Barclays Bank from 1980, the trustees allowed the company in which most of the trust fund was invested to make some highly speculative and ultimately loss-making investments in property. And they were held liable for not exercising suitable care. So they should have kept a much closer eye on what was happening in the company, and when they realised they were engaged in these speculative investments, they were property deals in this case, then they should have taken some action. In Lucking's Wills Trust, a trustee appointed a friend to be managing director of a company, and the friend was pretty useless and they lost a lot of money in the process. So this was another case where there was a breach of the duty of care. And finally, we have the case of Nestle and National Westminster Bank, which we've also looked at previously in one of my previous videos. And in this case, a man, Nestle, left a great deal of money under his will in the 1930s. And this money eventually went to his granddaughter, and she was outraged to find that her rich grandfather was only worth a very modest amount of money. So it was a lot less than what she expected, a lot less than its real life value from when the trust was originally constituted. And one of the reasons the trust fund had done so badly was because the bank did not use the full scope of its investment powers. It had left the money in safe trustee stock, when in fact the trust instrument had given them the power to invest in potentially more profitable investments. So the trustee should have familiarised itself with the trust fund, and anything they didn't understand they should have taken legal advice on. Had they taken the legal advice, they would have realised they were allowed to invest in potentially more profitable equities than they did. So there is a duty on the trustees to familiarise themselves with the trust, and more specifically in this case, there was a duty on the trustees to familiarise themselves with the scope of investments made by the trust. Okay, so that is the end of this video, and we've still got a number of different trustees' duties to go, so there's going to be at least another couple more videos on trustees' duties. But if you have any questions about this video, then please leave a comment below and I'll get straight back to you. If you enjoyed the video, make sure you like the video and subscribe to my channel. Thank you very much for watching.